Good morning, Mr. Brown. Ms. Graham.
Thank you. Yesterday, I said to you that we had information available from Ashley Edwards that she didn't remember being told about Dr. Karch and the situation which arose with him. But overnight, I've been given a copy of an email that you sent on the 19th of January 2018. So in the period towards the end of the third period that we're talking about, after the final report had been obtained and prior to the Crown Council making the decision. But it was an email from you to Ashley Edwards saying, I suggest that we remove all reference to Dr. Karch on the basis that the previous Lord Advocate indicated to Amar Anwar that we would not be relying on him following his comments to a newspaper. So although Miss Edwards may not have a recollection, it does appear that you had sent that email to her advising her of the issues, and she acknowledged that subsequently on the same day. So at the time, you did do that. Yesterday, we were looking at period 2, which was the period between the first PERC report and the final PERC report.
Yes.
And we looked at your letter of the 2nd of September, which gave more detailed instructions. We'd looked through your statement and we'd moved on into 2016, and you were starting to talk about that. You had explained to me that in your statement, you said, my advice was given against a background where it was accepted that at all times race and racial motivation required to be considered as a continuous process as the inquiry progressed, and that an absence of overt racial motivation should not be regarded as determinative. Consideration of implicit bias and assumptions based on race in the overall approach required to be assessed as the investigation developed and the evidence was gathered. And that was part of your inquiry statement. And you'd explained to me that that was from the beginning of the end of from the beginning of the investigation to the end.
It should have been.
It should have been. At the conclusion of period 2, which we've been talking about, the final PERC report was sent to Crown Office.
Yes.
And that was just over a year after the first PERC report was sent. And so this morning I'd like to move on to that third period, which was from the 10th of August 2016, when Crown Office were sent the final report, up until the point at which the Crown precognition was sent to Crown Council, and we know a decision was made at that stage. And I'm not going to be asking you any questions about the decision or the rationale for that. But that period between August 2016 and 2018, roughly around a couple of years, if we can think of it that way, between 16 and 18.
Yes.
And is it fair to say that it was during this period that the Crown investigation in the real sense of the word is being conducted? The Crown precognition is being prepared, and the Crown are on their own at this time in a sense. There's no involvement of Police Scotland, and there's no involvement really by PERC at this time, other than some specific
Yes.
points. But really this is where the Crown come into their own in a sense.
Yes.
Now, we've talked about your team, and the inquiry's been advised that Alistair MacLeod, and I think you mentioned this the other day, Alistair MacLeod was seconded to your team to deal with specifically with the investigation into Mr. Bio's death.
Yes.
And we have some information that it was in the September of 2016, so the month after the PERC report was obtained, that he had a meeting, I think with you, Lindsay Miller and Stephen McGowan. And Erin Campbell was there, and he was told she was going to be working on the investigation as well. And at that, a couple of days after that meeting, he was given copies of the PERC report to start reading into the events and the investigation.
Yes.
Does that all match your recollection?
Yes.
Thank you. So, as I understand your evidence, Alistair MacLeod and Erin Campbell were appointed as precognosers to this investigation, and there was 2 of them to work jointly.
Yeah. Yes, there is. They were appointed as regards precognosers. That sometimes means, just for the avoidance of doubt, it means what are known as precognition officers, who are non-legally qualified within Crown Office. But Erin Campbell and Alistair MacLeod were not precognition officers, so weren't in the traditional sense precognosers, but were both legally qualified and had considerable experience, as I've explained I hope in my statement. Experienced, but also I think of more senior grade. I think they were both what were called senior deputies in old grading. So senior legally qualified procurators fiscal.
Thank you. You've talked on the first day you gave evidence about some staff being full-time, some part-time. Were they both working full-time on this investigation?
To the best of my recollection, they were appointed on that basis, and so they could be called upon to assist. Whether they worked on it each day, depending on what the work that was done, is maybe more open to question.
Did they continue to carry an existing workload?
I understand that they did. Particularly Alistair MacLeod, because I do remember during the course of the investigation being approached by other managers to ask, well, if we had this piece of work, would Alistair MacLeod be able to assist with that? And sometimes that happened and sometimes it didn't. So that was the kind of picture in relation to.
Thank you. Now, we've heard evidence about something called the Precognoser's Handbook. And we heard evidence from Fiona Carnan about that and about something called the Knowledge Bank.
Yes.
As I understand the position, these are sources of guidance available to people taking on this role of precognosing in relation to a Crown investigation such as Mr. Bio's death. Is that correct?
Yes.
And the Precognoser's Handbook, and I won't go to it unless you want me to, it talks about pre-allocation of a precognition. Prior to the allocation of the case for preparation, it must be read by the solemn legal manager. And as I understand it, you were in the role of solemn legal manager.
I wouldn't say I wasn't in the traditional sense. Yes, I was to some extent involved in the assistance and the supervision. Yes.
So you were not only head of Cap D and running the unit, but you were also taking on the role of solemn legal manager in relation to this particular investigation. Is that fair to say?
I do consider that this particular investigation within Cap D had particular challenges and particular differences. I'm aware of the contents of the Precognoser's Handbook, but whether it was a traditional solemn legal manager arrangement, I question that, and I question that to some extent for the reason that both were legally qualified, whereas quite a bit of the Precognoser's Handbook is, in my view, intended to cover a situation where a non-legally qualified precognition officer is dealing with the precondition, and also in recognition of the fact that at round about this time, I don't think I'm wrong in saying that Ashley Edwards became involved. So in fact, the Crown team was more diverse and a little bit more expansive and unusual than the traditional arrangement between a single precognoser whom typically was non-legally qualified, and a solemn legal manager who would be legally qualified.
And in a traditional format, there would be one precognition officer, maybe not legally qualified, with one dedicated solemn legal manager.
I would say that's the most common arrangement, yes.
But in this particular investigation, Alistair MacLeod and Erin Campbell were taking the role of precognition officer, but both were legally qualified, and they worked together. And they, as I understand it, prepared the narrative. Fiona Carnan prepared the analysis. And other than the work you did, there was no other dedicated solemn legal manager.
Yes.
But in the sense that the solemn legal manager would normally countersign the Crown precognition, which contains both the narrative and the analysis, that was your role in this investigation.
I saw that as my role.
So you signed it, and that is akin to the traditional approach of the solemn legal manager who would normally countersign.
Yes.
And in the sense that you countersigned, does that mean that you had some responsibility in relation to the Crown precognition?
I saw it as my role to indicate whether I was in agreement with the conclusions of the precognition in respect of the recommendation that was made.
And can you explain to people listening, in that role, akin to a solemn legal manager, what is the job of a solemn legal manager? Presumably they have to read the narrative and the analysis.
Yes.
And do they read beyond that? I mean, in this investigation, did you read beyond the narrative and the analysis? Or is that generally sufficient to give you a view on whether it meets an acceptable standard?
What I would say in relation to this, and again I'm coming back to the traditional precognition role, and the traditional precognition role of the solemn legal manager, at the risk of oversimplification, it's a little bit like a conveyor belt where a precognition is produced and then the solemn legal manager will start to read their way through it, in essence, from page one. Whereas in respect of this case, I do consider that there was a more collegiate approach adopted in relation to the preparation of the case, standing that the precognosers, that's Alistair MacLeod and Erin Campbell and latterly Fiona Carnan, they were very much embedded from a legal perspective in relation to the investigation and would have a very detailed knowledge because they were working intensively on it, whereas I had wider responsibilities as head of CAPD. So I do consider that was a factor. It was also, I think, a factor in relation to this case, as I've said, that dedicated Crown Counsel had been very, very closely involved in certain aspects of the investigation and had consulted with a number of witnesses, and had also been in discussions and meetings, strategy meetings with the team. So I think I did refer to this in my statement. To some extent, it was a more collegiate approach rather than a conveyor belt approach in relation to it. But yes, I did see it as my responsibility to indicate whether I agreed with the conclusion that was made.
Did that still require you to read through the entire narrative and analysis and determine whether you agreed with the conclusions, or was it more of a light touch with this particular investigation, where you were simply looking towards the conclusions and recommendations?
It was a long narrative and it was a detailed analysis, and I paid particular attention to that. I had familiarity with other aspects of it and in relation to my involvement in the case, and I factored all that into the end result in relation to this. Crown Counsel had indicated that they wished a precognition. Of course, I was going to say Crown Counsel get what they asked for, but Ashley Edwards was of course entitled to a precognition in relation to this. But the precognition was being produced, as I've said, at I think various points in my statement, for a very specific and limited purpose. It was produced for the specific and limited purpose of Crown Counsel being able to reach with confidence a decision in relation to criminality. And depending on the result of that decision, there was the possibility of further inquiries being carried out by the Crown once that decision was made. So I do want to make that point, that it was created for a very specific and limited purpose, and that depending on what further procedures had been adopted, there was the very real likelihood of further investigations by the Crown that would have prepared for a subsequent inquiry phase, if I can put it like that. What I was looking to satisfy myself on was whether the basis for the recommendation was made sense from a legal point of view, whether it accorded with the information that I was aware of in respect of the case, but in recognition also that there may well be further work that required to be done, and that in particular that the extent of the further work that had been done since the submission of the final PERT report, that further work was, I suppose, rigorous enough and detailed enough to enable Crown Counsel to make a properly informed decision, but also to exclude the possibility of something emerging or being discovered later on that could affect that decision when the Crown had already made the decision not to take criminal proceedings if that was the instruction. So that was always, in my mind, a risk because there would be significant consequences in relation to embarking on an inquiry phase of the case if a decision had been taken that criminality could be excluded. So the focus was on criminality at that stage.
Perhaps you can help us understand, in relation to your normal Crown precognition, and you've said that this Crown precognition in the investigation of Mr. Bio was for a specific and limited purpose, designed to allow Crown Counsel to, with confidence, reach a decision on criminality. Can you help the Chair understand what the difference was between a normal Crown precognition and this particular Crown precognition? Are you suggesting that the precognition in Mr. Bio's investigation, in the investigation into his death, was less detailed in some way, or?
I think the short answer to that is no. Certainly not less detailed, but it was a Cap D precognition, and a Cap D precognition has got certain additional requirements as regards what should be included in it. It includes such things as an officer's complaints and discipline history. But what I would say in relation to Cap D precognitions, and I'm going to use an expression that has been used by others, and I think was referred to in the inquiry by Dame Eilish Angelini, that irrespective of the nature of the crime, that Cat D precognitions are expected to be of the highest standard and the most detailed in respect of the inquiries, for the purpose that if criminal proceedings are recommended, those are the cases which actually have to go to law officers, and that the comparison, which I'm quoting to some extent, but I think it is borne out, that all Cat D precognitions are prepared to a high court standard, in that they require to reflect the highest standards of investigation, and it is also reflective of the fact that there is a constitutional and a very onerous responsibility on the Lord Advocate to ensure that criminal allegations against the police are thoroughly investigated.
Thank you. But in relation to the investigation into Mr. Bio and the Crown precognition that was produced, it's simply considered criminal proceedings and not other forms of inquiry such as FAIs, fatal accident inquiry.
No, it didn't, and I do consider that having regard to the, I would describe them as extensive further inquiries that the Crown required to make to reach the stage of Crown Counsel having confidence in the ability to make a decision as regards criminality, there would be very likely to be a significant level of further investigation for the different purposes of preparing a case for an inquiry phase. And there were certain limitations in the Crown in respect of the criminal phase that would not apply to the inquiry phase. Typically, that once criminality is excluded, one can conduct wider investigations, including potentially precognition and precognition of police officers who've been involved in the incident.
And other than looking in this Crown precognition, other than looking at criminality, is it fair to say that the Crown deferred consideration or investigation into the other areas, such as whether there should be an FAI or whether that was appropriate?
I don't necessarily disagree with that as a generality. Those issues, as they were considered relevant by Crown Counsel to the issue of criminality, would be considered. But I think it's fair to say that other areas were, if I use the term, unfinished business, and that those would have been, they would have come into sharper focus once that decision was made. It was very specific, and the purpose being very specific in relation to criminality, and as in relation to the risk that the Crown would have if the decision not to institute criminal proceedings had been taken and would then proceeded to an inquiry phase. There would have to be confidence that there wasn't going to be information that emerged that could affect that decision, and that is why the kind of inquiry that was carried out in relation to reviewing footage by the Crown in relation to the return of officers to Kirkcaldy Police Office. At one point in my statement, I have said that there are particular challenges in relation to investigating allegations against the police, particularly of assault, where intention is extremely important, and probably more important than in assault cases that don't involve the police. And any indication as to the motivation is highly relevant. And therefore, the focus of those types of quite extensive inquiry was to ascertain whether there was any potential comment that had been made that could put a different perspective on the actions of the officers. For instance, a loss of control, a loss of temper, or whatever. And it was that kind of focused inquiry that the Crown was embarking on in relation to criminality. But I do agree in general that the focus of those inquiries at that stage was very much directed to criminality, and it was what I've termed in my statement and was used in briefings to the Lord Advocate, an incremental approach to the investigation, and that was approved by the Lord Advocate. And incremental meaning, obviously, there would be a first stage, and the first stage was enabling Crown Counsel to take with confidence a decision in respect of criminality.
Thanks. So there was this focus on criminality, but regardless, really, of whether the focus was to be on potentially whether there were to be criminal proceedings or an FEI or any other type of inquiry, that there would be some areas that would be looked at regardless of the ultimate outcome or decision, and those would be the circumstances of the events at Hayfield Road. So whether it was a trial or an FEI, you would still want to have a very thorough and careful consideration of the circumstances, and that would also include any evidence about motivation or state of mind of the officers.
Yes, as it related to criminality.
And the other topics that would be consistently looked at regardless of the ultimate proceedings would be the cause of death. That would be a factor that would have to be carefully considered, thoroughly considered, whether ultimately there was to be a trial or an FEI.
Yes.
And the other factor would be race.
Race, continuously, but particularly in relation to this, as it was relevant to considerations of criminality.
Thank you. As I understand it, the role of allocating the Crown precognition and the work to be done on that would be ultimately the role of the solemn legal manager normally in a normal situation. And was that something that you had a hand in deciding to appoint Alistair MacLeod, Erin Campbell, and then laterally Fiona Carnan?
The decision to appoint them, I'm sorry.
To get them into, well, Fiona Carnan was in your unit already, but to get Alistair MacLeod and Erin Campbell in to start working on the precognition, was that something that you were party to?
I do think it was largely Lindsay Miller that secured their services.
Okay, and the Precognoser's Handbook, which talks about allocation of a case for preparation for the Crown precognition, says all witness statements submitted should be carefully considered by the solemn legal manager. If the quality and accuracy of the statements is inadequate, in normal course it would be the police should be asked at this stage to obtain statements of a satisfactory standard. Obviously it's PERC in this particular investigation who have been obtaining statements. And is that the type of work that was being done to appoint Alistair MacLeod, Erin Campbell, laterally Fiona Carnan, but looking at the quality and accuracy of the statements to see whether further statements should be obtained? Was that something that was done at the outset?
I think that the quality of the information that had been provided by PERC in its entirety, including the statements, would be considered by the team, and I'm confident that it was.
Whose role was it to read through all the statements that PERC had sent as part of the final report?
I had read a number of the statements, but at the time that Alistair MacLeod and Erin Campbell were taking over, the focus, first of all, as I think I explained in my statement, was that we agreed collectively, and with the agreement of senior officials in Crown Office and as part of the investigative strategy approved by law officers, that rather than rely on the statements provided by PERC in respect of the significant eyewitnesses, and in the light of the criticisms that Mr. Anwar had made as regards the approach to the obtaining of those statements, that it was appropriate for the Crown to immediately and as a first course of action to embark on the precognition of those eyewitnesses at the Crown's hands. So to that extent, the review of the quality of the statements was, I would suggest, less important, because we were actually going to be doing detailed precognition interview of the witnesses ourselves as part of the key focus initially.
Was there to be a detailed consideration of the statements prior to precognising the witnesses?
That I understand that would be part of the process, and that would be part of the investigation that both of them were carrying out at that time.
And when you're talking about both of them at this stage, that was Alistair MacLeod and Erin Campbell.
Yes.
And you said you'd read a number of the statements that had been sent by PERC. By this stage, had you also read the statements of the attending police officers?
I think it's my recollection that I did read some statements at an earlier stage, but I cannot say today what statements I looked at as part of that. And the reason for that was that in having two legally qualified people who were engaged in the process, that they would do that.
So Alistair MacLeod and Erin Campbell are legally qualified, and your expectation was that they would read the statements thoroughly before precognising witnesses.
Yes.
Now, the Precogniser's Handbook talks about an allocation note.
Yes.
Was there an allocation note prepared?
There wasn't a traditional allocation note prepared for the reasons that I've tried to explain to the inquiry. What there was, I have a recollection of, was that there was a I would describe it as an interview or investigative series of questions that I set out, covering the issues that I considered required to be explored with the witnesses, having regard to the ultimate purpose. So I did set out, as I recollected, quite a few bullet points as regards an open approach, what issues I considered were had to be explored. I think it covered the comparing, contrasting, and sifting of various accounts. In particular, some of the significant elements of the civilian witnesses, including Ashley Wise, the length, duration, actions of officers, those kind of things. So that was intended to cover the kind of issues that an allocation note would cover.
Thank you. Well, we have a minute from 2016, which I think matches the description that you're giving us. And while we look for that, that's COPFS 03853A. Can I say, in the Precogniser's Handbook, there's reference to this allocation note, and that's a note that where guidance is given to a precogniser on advice on witnesses and legal principles. Do you understand that that's what the handbook says, and that's what an allocation note is?
Yes.
But in this particular case, you prepared a minute. Do you see this on the screen? It's from yourself, yes. 15th September 2016. So just slightly over a month after the final PERC report's been received. And it's to a number of people, and it includes Alistair MacLeod, Erin Campbell, and Ashley Edwards.
Yes.
So this is at an early stage in the Crown precognition process, and you're preparing a minute for the people who will be working on this part of the investigation,
Yes.
as well as Lindsay Miller, Liam Murphy, and Stephen McGowan.
Yes.
Thank you. Well, I'd like to look through that with you. If we can move down the page, please. And it says, meeting at Crown Office Re Sheku purpose to identify key issues to be explored at precognition of relevant eyewitnesses to actions of police officers engaged in the restraint of Sheku. And so the purpose appears to be in relation to issues to be explored with the eyewitnesses at this stage.
Yes.
And it says, background, the final report was submitted in August. Following consideration of its contents, the attached minute was submitted to law officers, setting out a framework and timescale for investigations by the Crown. And that remained under consideration at the time you were preparing your minute.
Yes.
And then discussion. And this is where it says an incremental approach to the investigation, which is just what you've just said. And decision-making process has been proposed. Who had proposed it?
I don't know who first proposed it. It was certainly something that I considered was appropriate, and it was that it was approved as that approach.
And who approved it?
Well, I'm pretty confident that it was shared with everybody and with law officers. So it was approved.
Mr. Brown, can you
Sorry.
just explain this a little more to me, the concept of the incremental approach? You said a little ago that there would be, you agreed with Ms. Graham that there would be a number of core issues that would be looked at in any event. What sort of things would be left for further investigation in the event that no proceedings were taken?
In essence, if we moved on to post that decision, my lord, we would be looking at the wider issues that could be explored at a fatal accident inquiry, and I was of the view that could include factors such as race and exploration with the officers of their considerations, so wider than that. So anything relevant to a fatal accident inquiry. In essence, what we were doing here was trying to reach as quickly as possible a stage where Crown Counsel were able to exclude or otherwise criminality, and then allow the wider investigation to move forward in relation to issues that were considered relevant to a fatal accident inquiry.
In relation to precognising the police officers, if, as I understand to be the case, the decision was no proceedings meantime but reserving the right to prosecute, then you wouldn't be precognising the police officers, would you?
Well, that would be a decision that would obviously require to be made at that stage, my lord. The proper preparation for an inquiry might well involve those types of approaches, and it would be pure speculation on my part as regards the extent to which that would be approved. But in order to make any inquiry effective, I would suggest that those considerations would have to be addressed.
Can you give me any other examples of investigations that you would carry out in the second stage?
Well, I think I've indicated that at a second stage, the wider issues of race could be considered at an inquiry phase, and those it would be a balancing act, but those could be explored with the police officers depending on the view that was taken as regards how effective the fatal accident inquiry could
No
be.
doubt Ms Graham will be exploring the issue of race in due course, so I'll just leave her to do that.
Thank you.
Thank you.
Thank you. And then moving on in this minute, it says, before any approach is made to expert witnesses, it has been agreed that the Crown should precognose all civilian eyewitnesses who observed the arrival of the police at the locus and the restraint process, together with ambulance personnel who were involved in the transportation of Mr Byle to hospital in Kirkcaldy. Thereafter, the evidence obtained at precognition will be disclosed to expert witnesses for comment. In my view, it is likely that the precognitions themselves, or at least the relevant parts that are disclosed to the experts, will also require to be disclosed to Amar Anwar in relation to his own expert witness instruction. Can we have that paragraph on the page, please? So does it appear that the initial approach for Mr MacLeod and Ms Campbell was to do a thorough precognition of the eyewitness, civilian eyewitness witnesses? Sorry.
Yes.
And those who had observed the arrival of the police and the restraint process. So that entire period, moment in time, periods in time when that was happening. And in terms of identifying those eyewitnesses and deciding who was to be precognosed, was that a role for Mr MacLeod and Miss Campbell?
I think it was a role for all of us.
Were you involved in identifying the particular witnesses who were eyewitnesses and who were to be precognosed first?
I think I was aware who was going to be approached, and that accorded with those whom I considered fell into that category.
There was a witness called Robert Cruikshank who had woken up and gone to his window and seen the arrival of the police. He wasn't precognosed. Were there particular reasons why certain witnesses weren't precognosed and others were?
I don't recollect the considerations that might have been applied to that particular witness.
And then you were also going to speak to ambulance personnel. And then it says, the evidence obtained at precognition will be disclosed to expert witnesses for comment. Now, I think yesterday, in response to some questions from the chair, you were asked about, were you simply going to provide precognitions or parts of precognitions to the experts and ask them to sift through and make decisions about what the factual matrix was or the factual scenarios? Yes.
Yes.
Was it considered at all that whether the precognosers or the precognosers with you should develop certain hypotheses upon which they could put to all the experts so that there was a consistent approach in relation to the factual matrix for all the experts when they were giving opinions?
I don't recollect any discussion about that kind of approach.
Is that an approach that you would recognise as being of benefit in certain cases?
It might, with hindsight, be of benefit, yes.
And in terms of the approach that was selected, who was to decide which precognitions or which parts of precognitions were to be sent to which experts?
Apologise for the pause in relation to this. I was going forward in time because this was an expression of my view as at that point, and I don't recollect any detailed consideration being given at a later point in respect of this this whole situation, this whole proposition as regards the disclosure, because as I'm sure the inquiry is aware. there was a particular approach adopted later in this process that was directed by the Lord Advocate. So that certainly was my thinking at that time, but I don't recollect any detailed discussion to progress that.
As we'll come on later today to look, other experts were instructed and were sent letters of instruction and no doubt papers. What decision was made about the selection of papers that was to be delivered to each individual expert?
I think in general the team were aware of the importance of consistent disclosure as a matter of principle, and that the disclosure of witness statements that had been made in the past, that, as to my recollection, was continued with in relation to the particular experts.
Where further precognitions have been obtained, were they also to be sent to the experts?
I consider in general that it would be appropriate to, if there were information that contradicted the statements of witnesses, that consideration would have to be given at that point. But it is the case that in relation to some statements that had been provided, those were actually fuller and the recollections were fresher of some witnesses. So it was the case that I think was a factor in relation to the sending of information. But I'm confident that the team were alive to the importance of the effective provision of information to experts, and also the consistent provision of information, including to Mr. Anwar.
Were precognitions sent to experts for consideration? Or was it mainly original statements?
My recollection is that it was mainly statements. That's the best of my recollection.
So here where it says, before any approach is made to expert witnesses, it's been agreed that the Crown should precognose all the witnesses. Was that primarily for the benefit of the Crown, rather than, a way by which the instruction to the expert could be expanded or made?
Yes, well, as I indicated, one of the main purposes was to ensure that the statements were accurate and that no essential information that could relate to criminality had been omitted. So that was the purpose.
Was there any reason why the Crown couldn't simply move forwards with instructing experts, rather than waiting until this first stage of precognition of witnesses has been completed?
I think the view that was taken was that there was an importance, in the light of the criticisms that had been made by Mr. Anwar, that the Crown carried out inquiries at their own hand in order to satisfy themselves that the statements and the position of witnesses was full, accurate, and had not omitted any essential information.
Right, and it then says towards the end, in my view, it is likely that the precognitions themselves, or at least the relevant parts that are disclosed to the experts, will also require to be disclosed to Mr. Anwar in relation to his own expert witness instruction. So at least at the point of time at which you were writing this minute, did you envisage that precognitions, or at least parts of them, would be getting sent to experts?
It was clearly a consideration at that point.
All right. And how did the Crown approach here in relation to the statements and the precognitions being sent to experts? How did that compare with what we heard yesterday about the expert witness package that PERC had prepared? Was there steps taken to ensure consistency?
I think one of the main purposes was to ensure that there was no essential information that had been contained within the PERC package that had been omitted and that the package continued to be a proper basis to proceed on. That was one of the main purposes.
So did the Crown follow on with the same approach and the same expert witness package as PERC had prepared?
I'm not terribly sure of the position in relation to that, but my recollection is that there was continued use of the package.
And was that for all the experts that the Crown instructed after the final PERC report had been received?
I'm sorry, I couldn't say for certain in respect of that.
Was it anyone's role within the team to ensure that the information given to experts was consistent? And if there were any variations of significance that, say for example, someone in the past previously instructed had something omitted, or that the Crown would go back and ensure that they were then provided with that significant material?
I think there was a level of awareness within the team that those factors were important, and that the consistent provision of information with those experts that had already been instructed was a factor in order to obviously ensure that experts were proceeding on the basis of the information that had been provided to others. Otherwise, the risk was it became a continuous cycle of having to go back repeatedly to experts.
Presumably you'd also want to avoid a situation where you're looking at two different reports about a similar subject. One expert has had one version of the factual matrix provided, and the other one has had a different version, perhaps that could be significant to their ultimate opinions.
Yes.
So you'd want to ensure there was consistency, at least with the material that they both had.
Yes.
But you were confident that your team would be alive to that possibility and rectify it if the situation existed?
Yes.
Was there any discussion about that? Or did you ask for reassurance in relation to that, or were you confident in your team and comfortable with your team?
I think I recollect some exchanges by email that emphasised the importance of consistent provision of information.
Thank you. And then moving on, it says Mr. Anwar has been critical of the investigative approach taken by PERC in relation to obtaining statements from civilian witnesses, observing that similar distinct phraseology appears to have been adopted by a number of independent witnesses, indicating concerns in this regard. Against that background, it is suggested that an old-fashioned approach to precognition should be adopted with the eyewitnesses, allowing them to describe events in their own words, which should be noted verbatim, and that the role of the precognoser should be limited to seeking clarification by the use of open and non-leading questions. Was this something that you or your team had been concerned about? Similar distinct phraseology appearing in statements of civilian witnesses?
Yes, to the best of my recollection, that was the nature of some of the criticisms that had been made.
And had you seen examples of that within the statements?
They'd been highlighted.
Do you remember any of the witnesses where there were those similar distinct phraseologies used?
I don't recollect any just now.
And then it goes on to say, during the precognition of the eyewitnesses, areas of potential conflict with the statements provided by the police officers in attendance should be fully explored. Clearly, one of the main purposes of this initial precognition exercise is to ascertain the extent to which the account given by the civilian observers coincides with the accounts given by the police. I think you touched on this yesterday to some extent, where you talked about a comparison or an analysis between things said by independent civilian witnesses and things said by police officers who were in attendance.
Yes.
And was it also, you say here, to the extent that they were, the civilians coincided with the police accounts, were you also looking for areas where their observations, civilian observations, did not coincide with police accounts?
Yes, what I was trying to get across was the value of conducting an overall comparison from which it might be possible to draw conclusions. So whilst the approach was not to first of all to uncritically accept the account of the police, there should also be an attempt to ascertain the extent to which civilian witnesses were supportive of the police as well, because it's a twofold approach.
So looking at areas of consistency with the police, but also inconsistency with the police, to the extent that those inconsistencies should be explored with the civilian witnesses at precognition.
Yes.
Of your summary. And then you say, without wishing to be prescriptive, I would suggest the following critical issues require to be explored during the precognition process. And this is a series of bullet points where you identify areas which you've described as critical issues to be explored during the precognition process with witnesses.
Yes.
So let's look at the first one, the actings of Sheikh prior to the arrival of the police, including the question of whether police could see that Mr. Bio was not holding a weapon. Now this seems to be restricted to his actions prior to the arrival of the police, but as you mention what the police could see, was this designed to encapsulate what the police could see at the moment they arrived and what their observations were, as well as Mr. Bio's actions prior to their arrival? Or was it specifically designed to just restrict it to his actions prior to arrival?
No, the whole
thing.
The whole thing, yes.
Thank you. Then you talk about discharge of sprays, his reaction to that, the use of batons, the way they were deployed, the actions of Mr. Bio towards officers, including the circumstances surrounding his interaction with Nicole Short. You have a large bullet point regarding the restraint process, the actions of the officers involved, how Mr. Bio was brought to the ground, his position on the ground, and you say there should also be an exploration of whether there was any continued struggle on the ground and whether there were apparent difficulties in controlling him. So is this designed to cover the full circumstances of the restraint?
Yes.
Moving on, an exploration into whether any observed actions of the officers involved in the restraint could account for the injury to the ribs of Mr. Bio. And you comment on Professor Crane's report and also the issue of asphyxia. And we talked about that yesterday, that was a topic of interest.
Yes.
Explore the evidence from the witness Wise, that's Ashley Wise, that a baton was used across the chest of Mr. Bio near the throat, whether there was any support from other witnesses, and also that she indicated he was struggling and shouting for officers to get off him, and you asked that this be fully explored with that witness and other relevant eyewitnesses.
Yes.
So again, you wanted not just Ashley Wise precognosed about those matters, but the other eyewitnesses to the restraint to be asked questions.
Yes.
And then obviously in assessing the potential for criminal proceedings against any officer, identification would be critical. And that's because ID is one of the important things for the Crown to establish at any ultimate criminal proceedings.
Yes. It was recognised as a factor and potentially a challenge in respect of this case.
There should, as we continue, there should also be precognition of the ambulance personnel who attended. That's at the bottom of the page, including their actions on attendance and the subsequent transportation of Mr. Bio to hospital. And then in addition, during this initial investigative stage, all recordings of airwave broadcasts should be listened to and checked for accuracy with the transcripts provided by PERC, so the Crown can be satisfied as to the state of knowledge of the officers attending. Similarly, all video footage should be viewed. So again, here in this passage, you are raising the issue of the state of knowledge of the officers. Is this furthering the investigation in relation to their state of mind, what they knew on the day? And you've asked for an analysis or a comparison of the airwave recordings and the video with the different individual accounts that were being given, both by
Yes.
officers and civilian witnesses.
Yes, and one of the main considerations in respect of that was clearly, if I can term it, real evidence, real-time evidence, and that type of comparison, particularly in relation to the timing and the cross-reference to at what point during the restraint process, all of those would be relevant factors, and as I say, hopefully could assist in building as accurate as possible an overall picture.
We've heard evidence regarding airwaves messages and the timings that are available in relation to those. And so in regards to the factual position, you would have the benefit of reasonably accurate timings that could be used as a comparison with the events that were taking place.
Yes, I know that this proved to be quite an extensive and time-consuming exercise because the team had to explore various technical, and hopefully overcome various technical challenges in order to do that. But that again was considered important, and that assisted in relation to the later stage of compiling the so-called multimedia information that was compiled at a later date.
So is it fair to say that those areas you've invited the precognosers to explore very much focus on the factual events which occurred in Hayfield Road? And am I right in thinking that the outcome of this part of the investigation will be used to feed into the narrative that was being prepared by Alistair MacLeod?
It would, but I do want to highlight the fact that I know we're maybe still to come to the conclusion, but it says the forthcoming meeting will provide all of us. That I'm confident referred to a meeting between the investigative team and Crown Counsel, at which this, I think, was intended to set the framework or the background for further discussion, and to the best of my recollection, that was of assistance, and that meeting took place where there was further direction given by Crown Counsel.
Well, just before we come to the conclusion, let's look at the beginning. You've sent this minute, if we go back to the top of the page, please. You've sent this minute to, as we looked at earlier, Lindsay Miller, Liam Murphy, Stephen McGowan, Erin Campbell, Alistair MacLeod and Ashley Edwards, the Advocate Depute.
Yes.
Was it intended that everyone named there, including yourself, would be at a meeting to discuss the investigation into Mr. Bio's death?
I couldn't be confident in relation to every name in relation to it, but I am confident that Ashley Edwards was there, and to the best of my recollection, certainly Erin and Alistair were there.
So at the very least, your team were there, the two precognosers, Alistair and Erin, and the Advocate Depute who'd been dedicated or allocated to this investigation, Ashley Edwards, and yourself,
Yes.
who was head of Cat D.
Yes. To
And
the
let's-
best of my recollection.
Thank you. And then let's go back to the conclusion, which is towards the bottom. And it says the forthcoming meeting will provide all of us with an opportunity to discuss the most effective approach to this initial stage of the precognition process. Once that is finalised, it is likely that members of the team will advise Amir Anwar of the approach being taken by the Crown so that the family of Sheku can be engaged in the process. The Lord Advocate has indicated that he intends to meet with the family of Sheku, and it is likely that this meeting will be arranged in early October. So that would be the following month after this meeting.
Yes.
And the purpose of the meeting is really to discuss this initial stage of the precognition process.
That would appear so, yes.
Thank you. So let's have the bullet points back on the screen, please. Because there's some elements here that are not mentioned, and I'd like to ask whether there was discussion subsequently about these. You make no mention of the experience of the officers, their years of service, the type of work they've done, that type of thing. And in particular, there's no mention of the previous experience the officers had of attending knife incidents and how they were resolved. Was there any consideration of that aspect when you were looking at the factual matrix?
The purpose of this particular minute was to offer up areas for discussion at the forthcoming meeting for the exploration of these issues with the civilian witnesses.
Right. So these issues were exclusively to do with civilian witnesses?
To do with the forthcoming precognition process of those witnesses, as I recollect.
And in relation to issues to do with the officers or their state of mind, was there to be any consideration given to that?
The primary purpose of this part of the exercise was to ensure, so far as possible, that no important information had been missed or omitted in the accounts being given by the civilian witnesses as regards the behaviours and what they were able to observe during the course of the incident.
At what moment in time was there to be consideration given an investigation into the officer's state of mind?
That was part of the overall approach during the course of the investigation. So it was a, I would say, a continuous consideration of the team.
Right. Well, on the one hand, you say it was continuous. On the other hand, you said at this stage you weren't looking at that. So can you explain to me? Sorry, I'm maybe misunderstanding.
No, not at all. This was intended to assist, or at least facilitate, discussion in respect of the approach to the civilian witnesses, in order to get as clear a picture of what they saw in relation to the incident. As regards the behaviour of the officers, so far as that was relevant to consideration of criminality, that clearly would be part of the overall preparation of the precognition as it addressed potential criminality.
So at some point there would be consideration of the state of mind of the officers, what evidence may be available in relation to that?
Consideration in particular of the actions of the officers and whether the actions of the officers could amount to the commission of a crime at that stage, the actions of the officers, and so considerations as to their approach, so far as these would be relevant to the consideration of criminality, would be a factor for the team.
One of the first bullet point mentions the actions of Mr. Bio prior to the arrival of the police, including the question of whether police could see that Mr. Bio was not holding a weapon. To what extent was it significant to the Crown whether the police could see that Mr. Bio was not holding a weapon?
I think my thinking in relation to that was whether the position and the behaviour and what the witnesses could see could assist in any way as to whether he was in possession of a weapon. But clearly, if a weapon couldn't be seen by anybody, we would proceed on that basis, and the potential for the weapon would have to be a relevant factor. It's more designed to cover his whole actions in relation to this, as regards what the police could have seen in relation to his behaviour on their arrival.
So, possession of a weapon would be a relevant factor to the Crown's consideration on what the police could have seen, and presumably a relevant factor to their state of mind.
Yes, as regards that particular aspect, yes.
So whether or not he was holding a weapon could be relevant in relation to their state of mind, but I'm not entirely sure I see any other comments there that could be relevant to the police state of mind. Were you leaving out the police state of mind in this exploration of the factual position?
The focus was on ensuring that the accounts of what the civilian witnesses were able to observe was accurate, so that the Crown could proceed to explore other areas, confident that nothing significant had been missed.
So at this stage, you also make no mention of the previous experience of the officers with regard particular to attending knife incidents, or how those other knife incidents may have resolved. Was that specifically something you were going to look at later?
That would be, those kind of considerations were for a later time.
Right. And there's no mention here of considering whether to use a comparator, how these officers handled this knife incident, and whether they would have approached it differently if it had been a white man as opposed to Mr. Bio. That's not mentioned here. Was that something also that was going to be looked at a later stage?
Essentially, there was a specific purpose in these bullet points, and it was limited to the precognition of eyewitnesses as regards what they could see, and that was the main purpose of this particular.
And in terms of, there's no mention of the legal framework here, no mention of justification having to be provided by officers. Was there any consideration given to whether civilian eyewitnesses could perhaps provide some useful information to the Crown against that background of knowing that the police have to justify every individual use of force?
Well, that was one of the main purposes of this, I would describe it as fairly limited exercise, the start of the investigative process. Let's be as confident as we can that nothing significant has been missed during the course of the PERC investigation.
Would it not have been of assistance to set out some of the legal framework and to say, please explore the issue of justification? Because there may be objective evidence that's available to the Crown in that regard.
I have to say that there was a limited purpose, in my view, in relation to this particular memorandum. It wasn't intended to set out the whole considerations the investigation, but rather to focus on the start of the investigation and what we hoped could be achieved in the precognition process. And my thinking was, rather than say to Alistair and Erin, who were, I think I can say with confidence, very experienced in relation to this, and obviously could use their own investigative skills and bring to the investigation their own considerations. These were the hopefully helpful benefit of my thoughts, and were intended to explore areas for discussion along with the Advocate Depute at the forthcoming meeting.
So whereas in terms of the Precognoser's Handbook and an allocation note, there will be advice and instruction given on which witnesses should be seen and any legal principles that may apply. That was not the intention of this minute, to set out the legal principles that would apply, or gaining evidence that may have a bearing on those against that background.
No, I think that's fair to say, and the overall interactions in the team, including regular meetings with Crown Counsel and communications, that informed the approach in relation to this, rather than the traditional precognoser with legal manager, where there was a clear need for specific directions because of the non-legally qualified nature of the people. Here we were in a different situation with a dedicated Advocate Depute and two highly experienced members of the team.
So in this minute, there's nothing about the legal framework, and in the investigation in relation to Mr. Bio, there are two legally qualified precognosers, if I can call them that, and an allocated Advocate Depute who's clearly legally qualified.
Yes.
And did you then make the assumption that there would be no need to really address the legal issues in that company?
I was confident that the composition of the team, including the dedicated Advocate Depute and having regard to the experience, that was something that would be addressed, having regard to the overall expertise in the team.
Right. Thank you. So in relation to the civilian witnesses and looking at what they saw that may or may not have an impact on the state of mind of the officers or any of that, but exploring fully what they saw, you don't specifically mention observations of Mr. Bio himself. So the observations of eyewitnesses, civilian eyewitnesses, about his appearance. You talk about his actings, but no specific issues about his appearance at that stage.
There isn't, although I would have expected if there was something significant about his appearance, his behaviour, his actings, that would be the kind of thing that the precognosers would be in a position to record. It certainly wasn't intended to say concentrate on the actings but ignore the appearance.
And at this stage you were not considering at all other matters such as the training the officers had received or anything of that sort. This is all about what the civilians can see happened at Hayfield Road.
Yes.
And you do mention the ambulance personnel. I don't think that's on the screen at the moment. There we are. Precognition of the ambulance personnel who attended, their actions, attendance, that type of thing. But again, no mention here about cause of death, anything of that sort.
There isn't, no.
And no mention of race or race motivation or anything of that sort.
There isn't at this stage, no.
And was it the plan that that issue would be raised at a later stage? race?
that the intention was that all relevant evidence in relation to considerations of criminality would be addressed in the preparation of the ultimate precognition and in the course of the investigation. That was the intention, and that, so far as I'm concerned, was part of the reason that two legally qualified and experienced persons had been fortunately selected and given over to explore this case in isolation so far as possible. That was their role, and that was something that, as I said at the start of this session, that Lindsay Miller had facilitated in the light of the fact that it was recognised that CAPD had limited resources and that there required to be a team which would be able to, I suppose the term, progress investigations having regard to the extent of their skill set, rather than require a constant level of instruction and supervision.
When you mentioned the words there, in isolation, was that to be in isolation of issues to do with race?
No, I'm sorry, that was poorly phrased. I mean, in relation to the case as itself, the investigation into Mr. Bayo, to concentrate on that case rather than other work. That was to be their primary focus. So that's what I meant by in isolation.
Yesterday, and I recapped on that this morning, you talked about the background where it was accepted that at all times race and racial motivation required to be considered as a continuous process as the inquiry progressed. And an absence of overt racial motivation should not be regarded as determinative. Consideration of implicit bias and assumptions based on race and the overall approach required to be assessed as the investigation developed and evidence was gathered. And so I'm wondering why at this stage there's no mention of race, not just in relation to perhaps overt things, actions or words that have been used at Hayfield Road, but why is there no line of questioning being proposed for the civilian witnesses about things that may ultimately impact on this question of race and racial motivation? And to give you an example, I'm thinking about the speed at which officers adopted the use of force.
Yes, I consider that this guidance note would enable the precognosers to be able to concentrate on relevant factors and all relevant factors. So I would be, although there's no reference to speed, that overall the full picture that would emerge would assist with that. But I do come back to the point that it was clear at this point by the incremental approach that the focus was upon criminality, and that issues as regards race were relevant so far as they related to criminality, and that to some extent implicit bias was something that would require to be explored at a later stage.
You talked about all the relevant factors being raised, but was race not one of the relevant factors at this point?
Race, obviously race was a relevant factor at all times, and I was confident that from the discussions and the overall approach of the team, that they were aware that race was an issue, and therefore if they were alive to any relevant evidence in relation to race as it would refer to criminality. But it is true to say that the the incremental approach meant that certain considerations of implicit bias, in particular an exploration as to why certain courses of action were adopted on the part of the officers and what considerations they took into account in having those would require exploration at a later stage of the process.
Yesterday, I asked you about the approach taken by PERC to take cognizance of issues of race if they emerged. And PERC talking about being mindful of issues of race or keeping an open mind. To what extent did your staff being alive to relevant issues of race differ from that approach that PERC took?
I think there was a recognition on the part of the whole Crown team, including the Advocate Depute, that there would obviously be further proceedings in relation to this matter and further investigations, rather, depending on the decision that would be taken. And therefore, awareness of the wider issues of race were within the consideration of the team, and certainly I would say that I was aware that there would be further work to be done in respect of race once this decision was made. But that was the focus of the investigation, and therefore I do say again that the considerations of race, so far as they were relevant to issues of criminality, would be considered by the team. But that was not the end of the matter, and that depending on the inquiry phase, that there would be further consideration of certain areas that would of necessity require exploration as regards the mindset directly.
Could we have the bullet points back on the screen, please? Because you've talked about awareness of the wider issues of race and further investigation being required. But at this stage, and please correct me if I'm wrong, it appears there's no actual questions even being suggested that civilian eyewitnesses are asked about whether there were any race-related matters that they had noticed or observed, heard, considered, anything that had struck them. So there's no mention of race at all, even in a sort of quite a focused small area, not even just looking at the wider area. Do you think, looking at that now, that there may have been benefit in specifically raising race at this stage to embed it at the very beginning?
There might have been benefit in looking at the overall note that was created for, as I say, a specific and limited purpose. But this was not the only source of instruction or information or dialogue in respect of the case. And I did consider that the team by that stage, in the light of all of the further inquiry and instruction that had been carried out, that there was an awareness that race was an important consideration in respect of the investigation.
So at this stage, the final PERC report's been obtained in August. This minute's being prepared in September, and there's going to be a meeting of the team after that. But at this stage, at the beginning, was there a specific instruction, not this one, but another one, that the inquiry could look at where race was addressed with the team specifically by you?
I'm not aware of any specific instruction.
All right. I'm conscious of the time now. Perhaps would that
We'll
be...
take a 20-minute break at this stage. Ms. Graham.
Thank you. I'd like to ask you some questions about one of the eyewitnesses in particular, Kevin Nelson. Now, in your minute that we looked at earlier, and we can get that back on the screen if it helps, but you said areas of potential conflict with the statements provided by the officers should be fully explored.
Yes.
And in the statements of the 4th of June 2015 provided by the police officers, primarily Tomlinson and Walker,
Yes.
they spoke of Mr. Biles stamping on Nicole Short's back. I'm summarising what was said
Yes.
there. But that was during the events as they occurred in Hayfield Road. And it'll be a matter for submission, but that was a significant moment in relation to the events.
Yes.
And it caused PC Tomlinson to strike Mr. Bile to the head and arms multiple times with his baton.
Yes.
And for PC Walker to shoulder charge, bear hug, shoulder charge Mr. Bile to the ground.
Yes.
And for the restraint to commence and to take place. Now, Mr. Nelson's statement made no mention of a stamp happening at Hayfield Road. So to that extent, he was not consistent with those police officers' statements. And as part of the comparison between civilian eyewitnesses that you've described to us and police officers' statements, was it part of your expectation that Mr. MacLeod and Miss Campbell would explore that apparent potential conflict between the two as part of the precognition process?
Yes, and to highlight that and to some extent to examine it and analyse it.
And maybe to ask Mr. Nelson whether he had seen a stamp or not. Now, is that the type of thing you would expect them to explore?
I would expect them to explore what the eyewitnesses saw and then carry out that comparison. Now, I'm aware that Mr. Nelson, as far as I can recollect, was one of the witnesses who was precognosed, and his account that was given was factored into the very full analysis for Crown Counsel, and that discrepancy, if I can put it like that, was not only highlighted but was analysed in respect of a number of factors, and I think I referred to that in my statement. I can recollect that that was a key consideration, and that it was compared with other eyewitnesses and also with the real-time evidence in considering the significance of this.
Mr. Nelson was precognosed by the Crown on one occasion, the 6th of October 2016. So this is in the month after your minute, where Mr. MacLeod and Miss Campbell are starting to precognose eyewitnesses. But he was never asked specifically about the stamp, the baton strikes, or the shoulder charge which brought Mr. Bile to the ground. Looking back, taking that from me and looking back, do you think that is an issue that should have been explored more fully with Mr. Nelson? I
think that the full account of somebody who witnessed certainly a significant part of the incident, that was something that hopefully would be explored and thereafter analysed and resolved.
So if it's correct, and what I've said is correct, that Mr. Nelson was not asked during the precognition if he'd seen a stamp, baton strikes in relation to the events at Hayfield Road, would you consider that to have been a failure on the part of the precognosers to carry out this process that you had described, comparison?
I don't know that I would describe it as a failure. What I would say is that I would be, the expectation would be that it would explore all of what Mr. Nelson saw, and if that, in relation to the stamp, if it did not include, if Mr. Nelson made no mention of a stamp, then that would have to be compared with the account of the other witnesses, the other evidence, and a consideration as to what the significance of that was. And from my recollection, I understand that that was the position, that there was a description, quite a full description of what Mr. Nelson did, where he was, what he saw, where he went to, how long that might have taken, but certainly there were, as I recollect, there were inconsistencies in the account of the police, not only, as I recollect, in relation to the stamp, but I think in relation to the use of a baton, which was something that the officers indicated. So to that extent, the whole process would not start and finish with what Mr. Nelson said, but inform where that took us with analysis and comparison and possible explanation in relation to the evidence of Mr. Nelson.
And Mr. Nelson described being at his living room window and then moving away from the window and going up to his garden gate.
Yes.
Up the path out of his house. And again, is that the period of that and the timing of that in relation to the events that were apparent to Mr. Nelson? Is that something that you would have expected to be explored in some detail?
I would expect it to be explored in some detail as regards what he saw and what he didn't see and what he did, and that then to inform a consideration as to what the significance or otherwise of that was. And as I say, my recollection is that discrepancy was not only highlighted but was commented on and analysed for the benefit of Crown Counsel, and clearly Crown Counsel would have been aware of that in taking their decision.
And then when Ashley Wise was precognosed, she was precognosed twice, once on the 4th of October, once on the 2nd of November. So dates that span the... Mr. Nelson was precognosed on the 6th of October. On the second occasion she was precognosed in the November, she said to the Crown, "My downstairs neighbour Kevin had a better view of this than anybody. He saw it from the start to the finish and I just saw the end." In light of that comment, would you have expected the precognosers to go back to Mr. Nelson or not?
I think it all easy to say, all depends on the facts and circumstances as regards whether it was considered that there was a necessity to go back to Mr. Nelson, or whether his observations, as well as where he was at the relevant times and where he went to, whether that account required a further visit to Mr. Nelson in relation to it.
We've heard some evidence that there was an attempt to go back to PC Walker to ask some further questions at a later stage. This was round about November, December 2016. So this is in the period where Alistair MacLeod and Erin Campbell are precognosing witnesses. And PC Walker, as I understand it, declined to provide a further statement or further information. Were you aware of that situation at all?
I'm thinking, I don't have a clear recollection of that.
Right. Well, I won't go into that. I'd like to move into 2017. So the final report's August 2016, and then work is being done by the precognosers, and then moving into 2017 now. And I think a number of experts were instructed by Crown at this stage. Was that work being done by Alistair MacLeod and Erin Campbell?
Quite substantially, yes.
Yes. So the inquiry has information that Professor Anthony Fremont, the osteoarticular pathologist, was instructed in the March of 2017. His reports were finally obtained in the May of 2017. He was the expert who looked at the fractured rib.
Yes.
So it wasn't a matter that related to cause of death as such, but it was in relation to the timing of the fracture, whether it could have been heard as it fractured, and potentially, I think you said yesterday or the day before, this could be relevant to the Crown in relation to the level of force that was potentially used.
Yes. And as I recollect, the identification of Professor Fremont was by Ashley Edwards in the light of the fact of involvement that she'd had with another entirely unrelated case where the significance of a rib fracture and the timing of a rib fracture, that I understand that Professor Fremont had had involvement in that. And although I actually don't think Ashley remembered his name, but there were inquiries with others in Crown Office and his name was disclosed. So that was the mechanism whereby that expert was identified, and I suppose that's another example of a line of inquiry that was instigated and ultimately seen to a conclusion at the suggestion of the dedicated Crown Counsel.
Now, you've explained to us that you had an interest in the fractured rib. It was of significance to the Crown. We looked at that in your evidence. I'm wondering, you've talked to us about Payne James. I think ultimately he was asked to comment on the rib. And I'm wondering why it took so long for the Crown to instruct Professor Fremont in March, which was March 2017, when the issue of the rib had been identified at an early stage and Payne James had already been asked to comment on that.
Yes, from my recollection, I think that the identification of Professor Fremont was quite specialist in that it focused on one of the areas that we mentioned, which I don't think anybody else had commented on, namely whether it was possible to ascertain or to estimate the timing that the rib fracture had occurred, as to whether it was at a time in relation to the incident or potentially before. So as I recollect it, that was one of the key considerations in approaching Professor Fremont, and it was something that I did explain the way that this was discovered. I have no idea when it was that Ashley Edwards made the connection that this might assist, and in relation to the case where he had given evidence.
We've heard from Professor Fremont, and again summarising, he is a highly specialist osteoarticular pathologist.
Yes.
And in fact, I think when he retired, the Home Office asked him to train up some additional people with skills, because his skills are rare in the UK. So we've heard his evidence, quite complex evidence that he provided to the inquiry.
Yes.
And then Dr. Lawler, William Lawler, was instructed. We talked about him yesterday briefly. I think he was another forensic pathologist, so the same role as Dr. Shearer, Dr. Buhadir, the same role as Dr. Nat Carey and Professor Crane. But I think yesterday you used the word oversight. And I wonder if you could explain why Dr. Lawler was instructed.
I think that if I used that term yesterday, I'm not disagreeing with it. I think I've seen in some of the emails the term reviewing pathologist, right. And that was a course of action that had been, I think, suggested by the Lord Advocate at an early stage in the investigation. So it was within the consideration that there would be some advantage in having a reviewing pathologist who would be able to take a view on independently on all of the pathology evidence that had been obtained, with a view to, I suppose, coming to a conclusion as to what this amounted to, and if there were differences, which area they could offer useful comment on. And that in particular, I obviously recollect, having prepared my statement, that the first mention of Dr. Lawler was not long after the incident in Kirkcaldy, and that he had been suggested after some inquiries with other pathologists, where the approach was very much focused on trying to identify a pathologist that had a particular experience in relation to crushing or positional asphyxiation. And that was a name, that is how Professor Lawler's name came up. And at the time that Crown Counsel were wanting to identify a reviewing pathologist, the full CV of Professor Lawler was forwarded, as I recollected, to Ashley Edwards, and Ashley Edwards considered that and approved an approach being made to Dr. Lawler.
In terms of the normal approach or the standard approach taken by Crown, is it common to have a reviewing pathologist instructed to review all the pathology evidence?
I can only say that I personally have not had experience of that. But as I indicated, the intention to consider and approach a reviewing pathologist was something that was clearly considered by the Lord Advocate, with a particular focus, as I said, on trying to identify somebody who had that particular experience. And I'm sure the inquiry will be aware that one of the factors was Dr. Lawler's experience in relation to the Hillsborough tragedy. He had apparent involvement in relation to that, and overall his level of expertise, and also I suspect the fact that he appeared to have, and this is a quote from the Lord Advocate, I think he used the term, an eminent or a heavyweight pathologist, and I think that the consideration in relation to that kind of reviewing pathologist was somebody who had a proven track record in relation to this type of work. Professor Lawler was independent. He hadn't worked in Scotland, but he was, as I recollect, a retired Home Office pathologist, but was still actively engaged. And my recollection is that was a key consideration that Ashley Edwards had. Not that he was long retired and perhaps was open to the observation that he was out of touch. He seemed to be able to demonstrate that he had kept up to date, was still actively engaged, and that he had sufficient experience to be able to carry out this role.
Now, leaving aside the particular criticisms of Dr. Karch, which we looked at yesterday, which he was to some extent an outlier or at odds with others, I think you said yesterday there was no criticisms of Dr. Shearer or Buhadir. So was it considered necessary in the particular circumstances because of any concerns about Dr. Shearer or Buhadir and their opinion?
Not at all, to my knowledge, but rather it was considered an appropriate way to proceed, standing that there were a number of opinions from experts, to use that term generally, that had been obtained, that an overview would be of assistance, and that seemed to be the view of Crown Counsel, and that's the way that Crown Counsel wanted to proceed. But to answer your question, not at all. And it is the case that even after the reviewing pathologist had provided input and had been consulted with, there was a further approach made back to Dr. Shearer and Bouhadir, in essence, to use the term, to bring things full circle. Here was further information that was available to the Crown, but it was important simply, I think, from the point of view that they were the ones who carried out the post-mortem examination. They were there. They saw Mr. Bayo, and therefore, to that extent, I think I'm right in saying they were the only ones that had seen that, and therefore that full circle consultation was always in contemplation. And as I said yesterday as well, some of the reports, and certainly the reports of Dr. Payne James and Dr. Karch, had been shared with the original pathologist at a much earlier stage to keep them to some extent in the loop as to where things were going.
So it was the Lord Advocate, that be Frank Mulholland, who raised the issue of Dr. Lawler being instructed to provide this review, and then that was supported by Crown Counsel. It was
Frank Mulholland, as I recollect it, that raised the question of the benefit, if I can put it like that, of having a reviewing pathologist. As regards the identity of the reviewing pathologist, I think there are emails where I have suggested or put forward that it was suggested to me and to others that Dr. Lawler was an appropriate person. But that wasn't Frank Mulholland who suggested Dr. Lawler. He'd suggested another eminent retired pathologist who was retired and really who wasn't doing consultation work.
So
and
the Lord Advocate's suggestion of an eminent heavyweight pathologist wasn't actually Dr. Lawler?
No, and that's probably what I think there is a fine distinction in respect of that. The heavyweight pathologist that he suggested was a different pathologist, but he was aware, to my recollection, that I had asked around, and I think I described it yesterday, that I'd first of all gone to one pathologist who approached others, suggested Nat Carey, and then suggested somebody whom he described as equally good in regard to this as Bill Lawler, and Dr. Lawler was, the Lord Advocate was cited that Dr. Lawler was under contemplation in respect of that.
So in principle, the concept of a reviewer, although you've not come across this before, came from the Lord Advocate, and then Crown Counsel considered all the issues about identification, and Dr. Lawler was instructed.
Yes.
And that instruction started in March 2017, and there were 4 instructions, I think, to Dr. Lawler about separate matters, and his reports came in, 4 reports, the final one arriving on the 21st of May 2018. So that process of Dr. Lawler being involved, being instructed and providing all the reports took about 14 months.
Yes, I couldn't remember the dates of the reports, but it wasn't just the one report, you're absolutely right in saying, and then he was asked to comment on a number of further matters. What I do remember in relation to Dr. Lawler, in particular the consultation, and I know you might be coming on to this area, but it was as part of the reviewing process, it was Dr. Lawler who suggested further inquiries be made in relation to sickle cell trait.
Can we look at the first report that Dr. Lawler produced, COPFS 00033? And this is a document that you see it's headed Dr. Lawler, 22nd of May 2017. This was in relation to his first letter of instruction, which had been sent in the March, and it was sent to Mr. MacLeod, Senior Procurator Fiscal Depute.
Yes.
And I'd like to go through this. This is a 29-page document, and I don't wish to go through every single paragraph, but I'd like to quickly go through some of the elements, if I may. So you'll see that he sent this to Mr. MacLeod. Thank you for inviting me to review the various reports obtained in relation to the above case, and particularly those dealing with the cause of death, and to comment upon the pathological aspects of this case, including methodology and approach adopted in your very helpful letter of instruction. So he's responding to the instruction to carry out this review.
Yes.
Could we look first at page 9 of 26? And he says at the outset, may I say at the outset that I have no criticisms of either the methodology or the approach adopted by Dr. Shearer and Bouhadir in this case, or indeed of anyone else instructed. So he's not criticising Dr. Shearer or Dr. Bouhadir.
He's not criticising the methodology or the approach adopted by them, yes.
Yes. Thank you. And can we then look at page 11 of 26? And on this page he makes a comment about Dr. Lipsitch. Here we are. So he's been sent the report by Dr. Lipsitch to also review. Dr. Lipsitch was a consultant psychiatrist. Now, is it fair to say that's a completely different area of specialism from a forensic pathologist, which is what Dr. Lawler was?
It's a different area of specialism.
Different area of specialism. And Dr. Lawler, if we can move on to the next section, perhaps we can move further down. He says this expert confirms that I, as an acknowledged non-expert in this field, had concluded. So Dr. Lawler acknowledges within the report that he is not an expert in the field of psychiatry.
He does.
He has no experience or qualifications in the field of psychiatry. And in fact, he's not in any position to comment on the report of Dr. Lipsitch, is he?
I'm confident in the first place that if he didn't consider that he could offer anything useful in respect to this, he would have disclosed that. But having said that, and in reflecting on the question that you're asking, it is the case that pathologists can develop experience, if not expertise, in relation to certain areas. I mean, typically, there was comment that you highlighted yesterday where Dr. Shearer and Dr. Bouhadir had commented on excited delirium and certain comments for the assistance of the Crown. So to some extent...
I think they'd said that it wasn't a pathological cause of death,
yes,
but they were aware that there were issues in relation to excited delirium,
yes,
in the wider community.
Yes. But in relation to this, and I entirely accept that Dr. Lawler is not, that is not his particular field of expertise. It might be that he was in a position to comment upon the effect of drugs or from his general experience, but that's the only comment I would make in relation to that.
What value is there to the Crown in asking a non-expert albeit a pathologist, to comment on something that a psychiatrist has said?
It would, the overall behavioural aspects of this incident were of significance in relation to the deceased, like Mr. Bio. And to that extent, it appears that in relation to this instruction, which, as I recollect it, was substantially done through the investigative team, that this might be of some assistance in relation to the decision that had to be made.
A forensic pathologist, the experience they have relates to performing autopsies and dealing with the deceased. And a psychiatrist will be dealing with human beings and their behaviour during life. What possible value could any of this have given to the Crown? To have a pathologist who deals with dead people comment on the opinion from a psychiatrist. I'm not questioning the value of Dr. Lipsage's report. I'm just wondering about the value of this review process.
It may well be in relation to this aspect that it would be of limited assistance, because, of course, when we see the comments, what Dr. Lawler comments upon is that he confirms that the expert had confirmed that the deceased was suffering from some severe acute behavioural disturbance, and he doesn't offer any further comment or perspective in relation to that, and it would appear he defers to the opinion of that expert. I'm surmising here and perhaps speculating as to why that was included, but perhaps the overall intention was that all of the reports should be forwarded to Dr. Lawler, but with hindsight, clearly Dr. Lawler wasn't in a position to offer any significant assistance, didn't offer any significant assistance, and therefore to that extent didn't really take that aspect much further forward. But perhaps it was for completeness. But I accept that he was not of any real assistance and didn't stray into commenting on something that he immediately acknowledged. I'm a non-expert here.
I don't wish to give the impression I'm criticising Dr. Lawler here.
Nor do I at
I'm
all.
looking at the issue of why this process was entered into.
Yes. I don't recollect any specific discussion as regards this. I'm speculating here, which perhaps I shouldn't, that the decision, once there had been discussion between perhaps Alistair MacLeod and Ashley Edwards, that the report should be forwarded for comment, and this was included.
If you had been asked to review the scope of this, or to contribute to the scope of this review by Dr. Lawler, what experts would you have limited his review to?
Well, I think the most important thing was in relation to, can I term it, principal pathology and the cause and mechanism of death, and in particular in the light of the area of expertise, the extent to which crushing or positional asphyxiation was likely had to have played a part, and the significance of that.
When you talk about principal pathology, we've heard that Dr. Lawler was a forensic pathologist.
Yes.
And obviously had experience in the forensic field in relation to pathology, which would be looking at deceased persons and preparing postmortems and that type of work. So when you're talking about principal pathology, are you talking about forensic pathology or something else?
I think that's probably what I meant when I used that term. I mean forensic pathology, and in particular the cause and mechanism of death, with a particular focus on asphyxiation.
Thank you. So if you had been asked about the value of this review process and the benefit that could be obtained from Dr. Lawler, would you have restricted his review to the reports of other forensic pathologists who were of the same field, the same expertise as him?
I might have. We may come on to that there was a consultation, but this was the first time I'd seen a reviewing pathologist comment, and to that extent, it did move on later on, as the inquiry will be aware, to a consultation where certain areas were further explored with Dr. Lawler.
Okay, thank you. And then, just for completeness, can we look at page 14 of 26? We have it here, Dr. Bleetman, who's a consultant in emergency medicine. And again, would you agree that's not forensic pathology?
It's not forensic pathology.
And I think Dr. Lawler recognises that he is not an expert in this field. He says he's, if we can move down, I think his comment appears down at the bottom, further down, sorry, at the end of this section. There we are. Dr. Bleetman provides what I, as a non-expert, considers to be a good review of the entity. But he's a non-expert.
He's a non-expert in relation to that. He does obviously comment upon certain conclusions that Dr. Bleetman reached about pneumatic chest compression, agree with comments about possible causes of the deceased petechial hemorrhaging, which, as I recollect, was a specific area that Dr. Lawler was in a position to comment on.
So Dr. Lawler, whose career and expertise is focused on the deceased, is commenting to some extent on the opinion of Dr. Bleetman, who's a consultant in emergency medicine, which is practiced in relation to those who are alive.
Yes, he is. They're obviously both in the field of medicine, and it's to my recollection, and in looking at the comment, he did consider that he was in a position to comment upon the hemorrhages as he indicates there.
At page 16, there's comment in relation to Dr. Shepherd. You mentioned her yesterday. She's a cardiopulmonary pathologist.
Yes.
And Dr. Lawler says, I can't argue when Dr. Shepherd states the heart is morphologically normal. That phrase, I can't argue, were you satisfied that Dr. Lawler had the necessary expertise to comment on anything that Dr. Shepherd was doing, given her speciality is cardiopulmonary pathology?
I recognise that's her speciality. As to whether, as a long-established forensic pathologist with considerable experience, it might be that they were in a position to make comment if they felt it was appropriate in relation to any conclusion drawn by another medical expert, or to say, I defer to them or cannot take issue with it. But it would clearly, at certain points in the report and here, he's indicating, as he puts it, I cannot argue, which is quite a colloquial way of putting it, but doesn't take issue with the conclusions of somebody who was approached who had a particular expertise in relation to this.
Right. And then on page 18, he looks at Professor Crane's views, and Professor Crane is also a forensic pathologist. So at least we now see that he's commenting on the work of another forensic pathologist.
Yes.
But he says there's nothing in any of Professor Crane's comments or opinions with which I can disagree.
Yes.
And in fact, he goes on to say he very strongly agrees with Professor Crane's opinion in relation to one aspect.
Yes.
And then we come on to Dr. Nat Carey. He's also a forensic pathologist, so the same specialty as Dr. Lawler. And if we can look at the comments in relation to Dr. Carey, He says, I agree almost totally with Dr. Carey in his interpretations, comments and opinions. And there's some further exploration there, but at least he's talking about other experts with the same specialty as he has, same experience.
Yes.
I won't go back to Dr. Karch, but we've heard evidence that Dr. Karch is not a forensic pathologist. I think we discussed this yesterday. So again, in relation to that, he is not matched with the specialty of Dr. Lawler.
Yes.
And then on pages 23 and 24, you will see that he moves on to Professor Fremont. Now, Professor Fremont was the osteoarticular pathologist we spoke about a few moments ago in relation to the rib. So not in relation to cause of death, but in relation to the fracture of the rib.
Yes.
And if we can look at his comments in relation to that. So Dr. Fremont is a pathologist, but not a forensic pathologist in the same sense as Dr. Lawler. He's
Yes.
got a very particular specialty in relation to osteoarticular pathology, which, as I understand it, relates to bones.
Yes.
And Dr. Lawler says here, he's commenting on the reviews. Sorry, can we go back up just slightly? Yes. He's dealt with Professor Fremont there. If we could just go down. And he says in his overview, although admittedly not within my field of expertise, I am sure, and he goes on to comment about acute behavioural disturbance and different aspects of that.
Yes.
Again, recognising at the outset that none of those are within his field of expertise.
Yes.
And his conclusion is given on page 28-29. And he talks about his opinion as to cause of death, having reviewed all of these reports, and it's sudden death in a man intoxicated by MDMA, ecstasy and alpha PVP in association with struggling and restraint. So apart from the inclusion of struggling, which I think was first suggested by Dr. Carey,
Yes.
in fact the cause of death remains the same, subject to the struggling element.
Yes.
And then there was a supplementary report, just for completeness, that Dr. Lawler prepared, COPFS 00034, and this is August 2017. And if we could look at page 2 of 6 first of all. And again, this relates to Professor Fremont. If we can look at the comments at the bottom. And I think, although I don't see it on the page, perhaps we can look down. He says, I readily accept I'm not a specialised osteoarticular pathologist. Perhaps it's on the, oh sorry, it was at the top of the previous page. The very top. Here we are. Sorry, I missed that when it first came on the screen. Although I readily accept that I am not a specialised osteoarticular pathologist, I do have a career background of diagnostic histopathology, albeit a long time ago. So is that the sort of expertise that the Crown were looking for in reviewing the position of Professor Fremont? A non-specialised pathologist in osteoarticular pathology and someone who'd had a background of diagnostic histopathology a long time ago.
I do come back to some of the observations that I made in respect of the purposes of a reviewing pathologist, which wasn't my own suggestions. To some extent, I recognise all of that. But in looking back to the time, I do consider that the purpose of having a review pathologist was to provide them with all of the information that had been obtained, not to get them to to analyse and to take the place of any other experts, but to take an overview having regard to the wide medical and pathological, and wide experience of being a pathologist in relation to the information that had been obtained, but with a particular focus, as I recollect, as I've said, on whether Dr. Lawler could comment upon any aspect of that within his own field of experience and expertise, but particularly in relation to the significant area of concern throughout the case as to the extent to which restraint and asphyxiation in particular appear to have played in the light of all of the findings. And that is just now the overview that I would take of the purpose of instructing him.
All right, thank you. We'll look at page 4 of 6 just before we complete. This is the final point in his report regarding Professor Michael Edelston as a consultant clinical toxicologist. So he was also sent his report, and then on page 5 of 6 we see his comments, the comments from Dr. Lawler. Although Professor Edelston's area of expertise is significantly different from mine, I found his report very interesting. So again, limited ability to review methodology, practice, comments in relation to the report of the Professor Edelston, which was significantly different in experience from Dr. Lawler.
There was, and I'll not reiterate what I said in relation to what I consider was probably the value, but in relation to that, I do again mention the fact that in carrying out this exercise and providing Dr. Lawler with all of the information, it was Dr. Lawler as the reviewing pathologist who suggested further inquiries to be carried out in relation to sickle cell, and the inquiry will be aware now. I know that you might be exploring this, but certainly the inquiry will be aware that those inquiries did reveal information that was potentially relevant to the overall circumstances. So to that extent, the value in having a reviewing pathologist, he was the only one that suggested this requires some further exploration, which was duly carried out, and revealing information that was, if I can put it this way, was considered of significance and was an additional area in relation to the cause and mechanism of death that did require exploration and analysis.
So we've heard that you've taken from me that this process took approximately 14 months with Dr. Lawler. Was there anything to stop the Crown going to Dr. Lawler as a very senior, eminent forensic pathologist and saying, please look at the information we have from other pathologists and tell us, are there any other further inquiries that we could possibly be carrying out?
I think the answer to that is there wouldn't be anything to stop them. The point was that Crown Counsel, to my recollection, considered that the most useful time to consult with the reviewing pathologist was towards the end of the whole process.
Right. So this now takes us on to, we can take that off the screen. I'd like to move into December 2017, so the end of 2017. We've heard evidence that Fiona Carnan came onto the team at the end of 2017, and that the team that existed, Mr. McLeod and Miss Campbell, were working on the investigation at that time.
Yes.
As I understand it, Mr. McLeod had started preparing the narrative at that time, and they continued to work on that, and also in relation to medical issues that were to be explored. Yes. So at that stage, I think the Crown, moving into 2018, also instructed a Professor David Rees, who was a haematologist, and Elizabeth Solyu, who was the histopathologist we spoke about, and Dr. Sebastian Lucas, who was another histopathologist. And there were aspects there in relation to the matter of sickle cell
There was.
that were explored.
I don't know that I recollect that Professor Rees was ever instructed, but certainly he was a name who subsequently referred us to other experts. There was a chain of communications that ultimately ended up with Sebastian Lucas.
Right. I have a note that a letter, undated unfortunately, was sent to him, and then a report dated the 8th of May, but it's not significant for my purposes.
That may well be correct.
So I'd like to look at 2018 and the consultations with experts that were going on during that period of time. I think from your statement, you say that you did accompany Ashley Edwards in relation to certain consultations.
Yes, I did.
And you mentioned Dr. Lawler, that we've just spoken about.
Yes.
Dr. Bleetman, is that correct?
Yes.
Dr. Rees.
Yes, there was a consultation. There was a meeting with Dr. Rees that was very short, where he referred us to somebody else. But yes, that would be right. There was.
Right. Ms. Solyu, Dr. Solyu.
I consulted with her because of the unavailability of Ashley Edwards.
So you did that alone or with a precognoser?
I did that on my own, but with input from, as I recollect it, from Ashley Edwards.
Right. And then I think you also consulted with Martin Graves, who was in relation to use of force and the police officer's actions.
Yes.
Separately. With regard to these consultations, just in terms of what guidance is given in the precognoser's handbook, and I won't take you to this, but it says there's a presumption that Crown experts will be consulted with in High Court cases. Is that your understanding?
It's my understanding that that the approaches for consultation in this case were the decisions substantially of Crown Counsel. So they, I think, assessed which experts they wished to consult with in order to assist them in the decision-making process.
Right. So where the precognoser's handbook in chapter 8 talks about a presumption that a consultation should be conducted with all Crown expert witnesses, including expert medical witnesses, unless it's routine or the defence have confirmed that it's subject to agreement or that type of thing. Was it your understanding that the precognosers would proceed on the basis that there was to be a consultation with all medical witnesses for the Crown, or that the decision would be exclusively left to the hands of Crown Counsel?
My recollection is that the decision as regards the timing, the approach for the consultation was taken by dedicated Crown Counsel.
Right. So you consulted with Dr. Lawler. The inquiry information is that was on the 30th of January 2018.
Yes.
Now, we only have the opportunity to look at the notes. We obviously weren't present there at that time. When you consulted with Dr. Lawler, did you cover issues about his qualifications and experience, insofar as both from the perspective of having some value in any comments that he's made about areas that you've asked him to look at, but also in terms of a knowledge about exactly where his specialism was? Now, there's nothing in the consultation notes, but I wonder if you did discuss that with Dr. Lawler.
I have no clear recollection of that particular aspect. I think that is my position, that I don't recollect that being explored explicitly. That's not to say that it didn't happen or there was some exploration in relation to it. And thinking back, there must have been some exploration of his experience and where his expertise came from.
Do you remember discussion about his experience and qualifications in any area of the consultation?
I have no recollection specifically in that regard, but as I've indicated, his CV and his experience were highlighted to Crown Counsel. So Crown Counsel were aware of that at the time of his instruction and obviously prior to the consultation.
Was it explored with Dr. Lawler how comfortable or otherwise he felt about commenting on medical reports where he was not apparently working in the same field, psychiatry, emergency medicine, that type of thing?
What I do recollect about the consultation with Dr. Lawler was that he was very open, and he was quick to indicate if he was if he wasn't confident in what he was commenting on. He was in a position to look and to explain in much more detail from his report about the conclusions that had been drawn. But as I indicated, and looking back, I do recollect that a particular focus was on the asphyxiation, what his experience of that was, and the hemorrhaging.
Did Dr. Lawler express any lack of confidence talking about issues to do with psychiatry, such as ABD, excited delirium? Do you remember any part?
I don't recollect any specific comment, I'm afraid.
As I understand it, there was a consultation with Dr. Solyu on the 16th of March 2018. Now, the consultation notes don't indicate who attended, but I understand it was yourself. You were one of the attendees, is that right?
I think I was the only one.
You were the only one with her?
Dr. Solyu,
Right.
yes.
And was there any discussion then between you and Dr. Solyu in relation to her qualifications and experience?
It may well have been that I reviewed her qualifications and experience, but I regret I don't have any specific knowledge or rather recollection in relation to that. Sorry, I was going to say, and we may be coming on to this, in respect of the contents of that consultation and the views expressed by Dr. Solyu, there was a formal request for a supplementary report, of course, in which she set out in detail where her expertise was obtained, and that was factored into her report, as I recollect.
I think there may have been some issue regarding the fact she is a general pathologist, not a forensic pathologist, and that may have been an aspect of required to know in terms of understanding her perspective. Was that explored at all by you at that consultation?
I'm sorry, I don't recollect exploring that.
Right. You consulted with Dr. Bleetman. Do you remember if there was discussion of his experience and qualifications?
Sorry, I've no specific recollection as to the detail of that.
Right. The consultation notes don't disclose whether there was any discussion of Mr. Bio's injuries and their mechanism apart from the rib injury. Was there any general discussion about injuries on Mr. Bio's body?
Who's that with? I'm sorry.
Mr. Bleetman, the emergency medicine expert.
I've got a limited recollection beyond what's recorded in relation to that. I'm sorry.
In relation to a number of experts, the inquiry doesn't have any consultation notes available, and it would appear that there weren't consultations conducted with these experts, but I'd like to check with you whether we're missing anything. We've no record of consultation with Dr. John Parks. Do you remember any consultation with him?
No.
Nothing with Dr. Maurice Lipsage? Do you remember a consultation with him? We understand he's...
No consultation, although I think I recollect a lot of dialogue and exchange of emails with Alistair MacLeod, but no consultation. I wasn't involved in that, no.
And was that between Alistair MacLeod and Dr. Lipsage?
Yes.
Right. We've no record of a consultation with Dr. Sebastian Lucas. Do you remember a consultation with him?
There was no consultation involving Crown Counsel and Sebastian Lucas, no.
With anyone else? And
No.
Sebastian Lucas?
Not a formal, no consultation in that sense, no.
In a different sense?
No.
Dr. Jason Payne James, no record of any consultation occurring with him.
No.
Dr. Mary Shepherd?
There was an attempt to have a consultation with Dr. Mary Shepherd,
Right.
but she was unavailable, so that was postponed and wasn't pursued. So that's right, there wasn't.
Professor Jack Crane?
No.
Dr. Stephen Karch?
No.
Presumably that would not have taken place after the views of the Lord Advocate were expressed.
There was no consultation with Stephen Karch.
Professor Anthony Fremont, the osteoarticular pathologist, no record of a consultation with him.
I've no recollection of a consultation with him.
And Professor Michael Edelston, no record of a consultation with him.
No.
Now, you've explained the attempts that were made with Dr. Mary Shepherd, and you've explained the position regarding Dr. Karch. But in relation to the other experts, 7 in total, why did you not consult with them?
I think all that I can say is that Crown Counsel made the decision as to who to consult, and it was a continuous process, and it would appear that Crown Counsel did not consider that a consultation with those others would assist in them in their decision-making process.
And in relation to the Precognitioner's Handbook, which says there will be a presumption that there will be a consultation, and there are often many benefits to be gained from consulting with experts, was that not something that you were concerned about, that there were not consultations being conducted?
Well, it might be the case that in the light of the fact that there was a reviewing pathologist, that assisted Crown Counsel in their decision making and didn't require any further consultation. Beyond that, I couldn't say.
And I'm particularly interested in Professor Fremont. We've heard evidence, as I said, from Professor Fremont, and he is an osteoarticular pathologist, which is a rare find as we understand it. Also very complex issues raised by him in his report. Was there any concern that perhaps one would need a consultation with someone like Professor Fremont in order to truly understand his opinion? Or was there a view taken that that wasn't necessary?
My recollection is that Crown Counsel did not explore nor discuss the possibility of a consultation with Professor Fremont.
And finally, because I'm conscious of the time, we've heard evidence that Fiona Carnan did not consult with any experts herself. Are you aware of anyone in your team precognosing experts instead of having consultations with them?
No, I don't recollect the answer to that specific question. No.
Thank you very much. Would that be an appropriate moment?
We stop for lunch and sit at 2 o'clock.